case number 19 CF 75. Appearances, please.
David appears by Jacqueline LeBrie and WBAY.
Timothy Hauschultz appears with Donna Kukler. Good afternoon.
Good afternoon. I was informed yesterday that the parties had reached an agreement. We have an 8-day jury trial scheduled to start Monday. What is the agreement, please?
May I approach with a plea question there?
You may, but I'd like to know what the agreement is, please.
Your Honor, my understanding that will be an
I'm sorry, Judge, can we get her to make
No,
that?
3 and 6.
Attorney LeBrie, we're having a little difficulty hearing you. Could you speak up a little?
I'm sorry, Judge.
Thank you.
The plea would be to counts 3 and 6. The state will move to dismiss and read in the remaining counts. The state is recommending prison.
Is that your understanding of the agreement, Attorney Cooper?
Yes, Judge.
And so we're clear, counts 3 and 6 are charges of party to a crime of child abuse intentionally causing harm as a party to a crime, both Class H felonies. Is that correct?
That's right.
Is the state in compliance with victim notification requirements as to this agreement?
Your Honor, the state did speak with the victim, did obtain the victim's witness, took that into consideration when making the offer. The victim, I believe, is present in court today.
And I did receive a number of letters that were submitted by the victim and by other individuals. Did the state also receive those?
I did receive those, Judge.
And did the defense?
About
Your microphone is muted. When did you receive them?
about an hour ago.
Attorney Kukla, did you receive them also?
An hour ago.
That's about the same time I did as well. This is a significant reduction. I need a record as to how this plea agreement would be in the public's interests, please.
Judge, the state did do an evaluation of this case. We took into account the victim's wishes. We also have a duty to be objective and not swayed by emotion.
Judge, I can't.
Your audio is cutting in and out.
Evaluation.
Attorney LeBrie, your audio is cutting in and out. I'm having a very hard time hearing you.
I'll speak up. Is this better?
It is.
Okay. We did an evaluation of the case. We did an evaluation of the facts, the status of the case at this point, the various parties involved. As the court knows, 2 of the other individuals have already been sentenced in this case. And after that evaluation, in discussions with defense counsel, we did reach this agreement. It does recognize 2 of the victims involved. It does recognize actions by the defendants. As far as each of those victims, I think that based upon the totality of everything in this case, that it is appropriate, looking at the facts, the burden of proof, and the responsibilities of the state.
I understand from the letters that were received that the victim, particularly the mother, is vehemently opposed to this plea agreement. Is there any comment from the state on that?
Judge, I know she's unhappy with this plea agreement. That happens in some cases. I have an ethical duty to evaluate the case objectively. We do have a duty to take into account the victim's wishes, which we did. And to be honest, you can ask Attorney Kukler, there was a lot of back and forth when we were negotiating this. And we did take into account her wishes, but this is the plea agreement.
You cut out at the end there.
We took into account her wishes, but this is the resolution that we felt appropriate at this point in time.
Can you tell me what has changed since we set this trial 6 months ago?
Judge, we've been negotiating. Offers have been extended throughout the years. As the court knows, this is a 7-year case. Throughout the trial preparation, we've been in communication with Attorney Kukler. Just recently, Negotiations have started again, and as the court knows, as trial dates come closer, that happens, and that's what happened in this case.
I need to tell you, I'm very uncomfortable with this plea agreement. I'm intimately familiar with the alleged facts in this case, having presided over the cases of both co-defendants and presided over this case for 6 years since it was filed. We have set aside 2 weeks to try the case. There have been more motions that I'm able to count quickly that have been filed and heard. And here on the eve of trial to come to an agreement that I'm really not satisfied reflects the public's interest in a fair outcome here. I'm very uncomfortable accepting this plea agreement. I'm aware of my own obligations to independently review a plea agreement and determine whether it is in the public's interest, and I'm not satisfied that it is. The allegations here are extremely serious, and I don't think that this amendment to 2 Class 8 felonies reflects that. There's a long list of factors that I'm to look at in determining whether something is in the public's interest, and one of them is whether I have the ability to appropriately respond to my view of the case. And this plea agreement gives me virtually no ability to respond. The sentence is basically a foregone conclusion in light of the credit that's already present here. So I'm not going to accept this plea agreement. I'm not satisfied that it satisfies the public's interest.
Are you going to hear, not willing to hear from the defense? You've reached your conclusion without hearing from the defense?
Well, Ms. Kugler, I'm pretty sure I know what you're going to say, but please feel free.
Can you speak into your microphone?
Yes, I certainly can speak into my microphone. I mean, I agree with the state, and although you're intimately familiar with the case, Judge, of course, having presided over it for years, you're not intimately familiar with the discovery in the case, because that's not something that's shared with the court, right? You have knowledge of what's in a criminal complaint, you have knowledge of some testimony from various motions hearings, which is limited knowledge that this court has. On the other hand, the state and the defense have much more knowledge than this court does, and including interviews with people that have been conducted who are, without naming names, right, there's been interviews conducted of various witnesses in this case who would say that my client did not put Damien in charge of discipline, that my client has never laid a hand on the children, other than maybe some little minor thing. He has imposed discipline of carrying wood. Okay, there has been the kids have been told to carry wood, but as this court also knows from recent filings, social services was aware of that. They were aware of what was going on in the home. They were aware that Damien was living in the home. Damien has taken responsibilities in prison for several decades, 2 decades, I think, at least 20 years. He does not take the position that Tim told him to do anything. The state and us are privy to interviews that have been done with Damien over the years, including recently, and we know what his position is and what he would say. And so when it comes down to it, and we're on the eve of trial, we can evaluate carefully what we expect people to testify to and see that the state probably cannot prove beyond a reasonable doubt most of the allegations in the case. Now, Tim is willing to take some responsibility. He is also devastated by the fact that Ethan died in this case. But we are really, talking to people in the last 2 weeks has become more clear as to where things are going to land at a trial here. And Tim is taking responsibility for what he did do, but not to what he didn't do. He didn't have anything to do with the death of nobody could foresee that Damien would go so crazy to bury his, nephew-in-law or whatever he would be related to Damien, bury him and beat him. There's no foreseeability on that whatsoever. Nobody would say that at trial. There's nobody who would say that anybody knew that Damien would do that. And certainly that Tim didn't ever tell Damien to do anything like that. And I believe the testimony that would be elicited at trial would be from everybody, would be that Tim, if the kids ever did roughhouse with each other or fight with each other, as anyone who's raised boys knows that they do, he would say again and again, keep your hands off of each other. That was Tim's approach with these children. Keep your hands to yourself. Keep your hands off each other. The charges are problematic. We've even litigated the delinquency of a child causing death with this court. I don't believe it can even be charged in this way. I believe that, and I know it's not settled in the case law, but I believe that in that particular crime, it would be required that the person whose delinquency one contributed to is the one who died. I understand that this court ruled against us on that issue. It seems to still be an unsettled issue as far as a court of appeals. There are a lot of issues here, and we are taking responsibility for what we did. And I think the court should take it because the lawyers are in a better position to know the strength of the case and whether the case can be proved beyond a reasonable doubt, which is what's required.
Isn't that true in every single case? Of course, I'm not privy to the discovery, but is there ever a case then where the court would have the actual discretion to make this determination that the Supreme Court of Wisconsin has directed repeatedly that we do?
Well, I've never had a court in 30 years ever reject a plea agreement.
I can tell you I never have either.
Okay, never had a court do that because the courts, in my experience, of very, very serious cases of every sort, take the position that the lawyers know best.
I think the courts typically have enough information from the attorneys to make a determination as to whether a plea agreement is in the public's interest. What I have here is that although this case has been pending for 6 years, the trial has been set for 6 months. Over the last couple of weeks, things have come to light that there are problems with the case. What I'm hearing, though, is your client is saying he never laid a hand on the children, so how can I accept this plea agreement either?
Because he had them shovel gravel and carry wood. And the state's position is, whether it was a 45-pound log that the kids carried or a 30-pound log that the kids carried, and we don't have an agreement on that number, but let's just use that argument. Either way, for 7-year-old children, that the state's position is that's extreme. And I can say that we can agree that that is possibly, that others could feel that way. I'm not saying that I personally agree with that, but I could see that a jury might agree that Tim having the kids carry a log that's 30 pounds could be abuse. Because it's, the state's position is it weakens their muscles and causes some bodily harm. Because it's too extreme. So that would be the basis for this. If the facts, there's a basis in the record for it.
I'm still not convinced. This is an extreme position I'm taking. I understand that. This is not something I am in the habit of doing. It's not something that I think any judge is in the habit of doing. But this case is also not quote-unquote run-of-the-mill. And the reasons I've been given make sense as to maybe a couple of the charges, but they don't make sense to me overall. And what I'm most compelled by is I have, as I said, absolutely no discretion as to anything as it stands right now. The sentence, as I said, even if I were to impose the maximum penalty on both, Mr. Hauschultz has already served the lion's share of that. So to accept the defense position is to say that Because the parties have reached an agreement, I abdicate all discretion and all authority over this case, which is simply not case law. That is not the role of a circuit court judge. I have an obligation to use my discretion to determine whether the plea agreement is in the public's interest, and I am absolutely not convinced that it is.
Well, Judge, I don't think that whether Mr. Hauschultz has served the lion's share of his sentence is an appropriate factor.
I think it's
Like,
100% appropriate.
why would it be? Because what if somebody has, on an OWI, sat for several months, you're not going to not accept the plea.
That's not the only reason I'm saying this is a problem, but let's look at State versus
Post
Kenyon.
bail, Judge.
I'm
That's
sorry,
right.
I'm sorry.
Ma'am, it's my turn to talk.
Sure.
I need this case again, Judge.
I didn't get that far yet. State versus Kenyon, we all know that's the prevailing case. And it cites Myers v. Frazier, that's 173 West Virginia 658, as a list of factors that I'm to consider, including the reasons given by the prosecutor and the defense, whether there's a voluntary plea, we haven't gotten to that point, factual basis for the plea, we have adjudicated that multiple times. The general public's perception that crimes should be prosecuted, I think that's satisfied, but the interest of the victim and the court's ability to dispose of the case in a manner commiserate with the seriousness of the criminal charges and the character and the background of the defendant. Those are two of the factors that weigh against this agreement. And then that same case cites offense, the threat posed to the public by the suspect, ability and willingness of the victim to participate, disproportion between the authorized punishment and the particular offense or offender, cooperation of the suspect with arrest and prosecution of others. There are others that certainly don't apply here. But those also weigh against this plea agreement. I've made my ruling, I've made my decision. I've considered the arguments made by the state and the arguments made by the defense, but I am not satisfied that this plea agreement satisfies the public's interest. I would offer the state and the defense time to go back to the table and continue discussions, or we can start trial on Monday. What would you like to do?
What do you mean, Judge? I'm sorry.
I said we can either start trial on Monday, or I can give the parties more time to go back to the table and continue negotiations.
Well, we would like a few minutes this afternoon, that's for sure.
Go ahead.
You'll file the plea agreement that I dropped off there?
I will give it to the clerk right now. We'll put it in the clerk file. All right, then, how long do you want?
Half an hour.
Okay. We'll come back here at 2:50. We're off the record.
Judge, anybody who leaves secure